Welcome to the Special Education Essentials for Parents and Families podcast with your host, David Tollner. In each episode, we'll have guests who are professionals in the special education and disability services industry who support children with special needs. The law is complex, and this podcast does not cover all situations, legal responsibilities, or variations in different circumstances. This podcast is for entertainment and informational purposes only, and nothing contained in this podcast should be construed as legal advice. The views expressed in this podcast may not be those of the host or the firm. We are not responsible for any losses, damages, or liabilities that may arise from the use of this podcast. This podcast is not intended to replace legal advice. You can find this show on all the major platforms including YouTube, LinkedIn, Facebook, Apple Podcast, Spotify, and on our website, TollnerLawOffices.com. Now, here's the host of Special Education Essentials for Parents and Families, David Tollner.
Yes, welcome everyone. Welcome back to episode number 3 of Special Education Essentials. Hopefully you have listened or seen 1 and 2, because this is the third in a line as we walk through how to improve the IEP of your child, right? And it started, we're going to go back. I should say I'm your host, David Tollner, and welcome to the show. If you caught us from the beginning, you'll have a sense of my background, so you know that what you're listening to has some merit. But you will also have heard 1 through 7 in our list of 10 essential factors or ways to prepare for an IEP so the outcome is far better for your child, right? So we started with record. You have to record every IEP from now on, 24-hour notice. Get a digital recorder or use your smartphone and record every statement at the IEP. It is essential that you do that. If you do nothing else that I tell you in the first 3 episodes, do that, and your IEPs will be better, believe it or not. Because you're recording, you have to be respectful, but also be firm, right? It's your child. What you can't do is be angry or vindictive or accuse people of doing things, of anything that is untoward, because that doesn't play well with judges in special ed. And then you have to prepare, right? You've got to be the one in the room that knows the documents better than anybody else, so that you can access pieces of it to support what you want. And then you need to know what you want, right? You can't go into an IEP, any IEP, thinking that the IEP team that is school-based is going to, one, have your child's very best interest in mind. They might, and if you're lucky, they will. Or that they're going to provide the supports and services that your child absolutely needs, right? You have to know what you want at an IEP so that you can prepare properly and put in front of that team all the evidence that they need to make the right decision, right? So record, be respectful, prepare, know what you want to achieve. And then maybe the second most important rule of all is ask 1,000 questions. You don't know what's going on in the classroom, so you have to learn so that you can be an equal member of that IEP team. That requires you to ask as many questions as you can think of the teachers and the adults in the room who have that information, because you don't. Otherwise, you simply will not be a very effective parent in driving progress for your child in that setting. All right. Ask for all the reports in advance of an IEP. Do not walk into an IEP if you can at all help it, and then without having the documents that are going to be discussed in advance. You cannot, I cannot, and I've seen thousands of these, walk into an IEP, get a 40-page report and expect I'm going to ask all the right questions about that report by the end of that IEP. Get the reports and the IEP drafts and everything in advance. And if you don't, you've asked for them and they say, yes, we'll give them to you in advance, and you don't get them in advance unless there's a very good reason, cancel that IEP. Take the time to review the reports in advance, and you'll do much better for your child. And then we ended with goals, which is number 7 of our list. We talked about the importance of accurate baselines right now and the importance of having a goal for every deficit area, right? You've prepared, you know exactly what your child's deficit areas are. You've looked at the reports, and you want to encourage that IEP team to have a goal for every deficit area, right? Not just 1 or 2, 10, 12, 15. I've seen 20 plus. And those are the best IEPs. We want every deficit area covered, and you have the legal right for that. So make sure that you impress upon the team the importance of a goal in every deficit area. Now, the last piece about a goal, we're going to complete number 7, that I want everybody to understand is there has to be an apples to apples comparison between the baseline and the goal, right? What you don't want is a vague baseline that isn't measurable and then a measurable goal, because the whole point of the goal is for that team to determine what we want Johnny to do in a year, what we think he could do in a year with the right supports. And if we don't know exactly where Johnny is right now, then there's no way to do that effectively, right? So you have to have an accurate baseline, and then you have to have an apples to apples comparison of that baseline with the actual goal. So I'll give you an example. For many of my clients, they need a lot of prompts, right? There's attention issues, maybe communication issues, processing issues. And so a lot of our clients need either an adult next to them or the teacher to constantly, or another adult in the classroom to prompt that child to stay focused on instruction, right? To engage. And many children really need a prompt or 2 or 3 or 4 or 5. And we want, or far more. And what we want is to lower those prompts sometimes, right? So that the child stays engaged independently. And ideally, the goal in a year's time would be pure independence. But sometimes that's a little too far or too much to expect, or a little too aggressive. And so if the goal says Johnny will only need 1 prompt to begin work on a classroom assignment, right, after an instruction was given, then the baseline has to have how many prompts Johnny needs right now, right? Apples to apples. The goal is a diminishing prompt goal. And so the baseline has to be exactly how many prompts are needed now, right? So another example, multiplication. Johnny will solve multi-digit multiplication problems with 80% accuracy in 4 out of 5 trials, right? Classic goal language. The baseline then can't be Johnny struggles with multiplication. Way too vague, right? Or the Woodcock-Johnson, it's very often I'll see baselines where they reference the standardized test that was given to Johnny, and literally they put Woodcock-Johnson subset, 2B. Who the heck knows what that is? Nobody does. And nobody but somebody that does this for a living, and nobody, including those teachers who don't give standardized tests, will have a clue. So anybody reading that IEP can't discern whether Johnny made progress or not, because the baseline is not a measurable thing, and because there isn't an apples to apples comparison. So if the goal for 1 year for Johnny is 80% accuracy on a given skill, and I mean any skill, not just multiplication, any skill that you're working on where we're looking for a percentage improvement, then the baseline must have where Johnny is with that exact skill today, right? The percentage. So if 80% of a skill is what we're after, in this case, multi-digit multiplication problems with 80% accuracy, I want to know what percentage Johnny is at right now with the same multi-digit multiplication problem skill, right? Apples to apples has to be, because that's the only way to keep track over time whether Johnny's making progress. The more vague the baseline, the more difficult understand if progress has been made. And if without an apples to apples comparison, you can't track it over time. And the reason that's important is not only because you're an interested parent, you want to see progress and you want to have progress proven to you. You want it to be data driven as opposed to a general statement from the teacher, Johnny's doing great. We hear that all the time. Johnny's doing great. We're really seeing great progress. Well, show me what's going on. Well, we don't really take data, but we're seeing a lot more engagement, and he's coming along very well with his multiplication facts, right, or his math facts, his basic math facts. And then you dig in because you're asking 1,000 questions. You don't let general statements go anymore, right? You can't. You have to get into the weeds. And you realize that Johnny has actually made very, very little progress. That if it wasn't for the one-to-one aide sitting next to him actually doing the math for him or writing the assignment for him, he's doing very little independently. So we really don't know whether Johnny's skill level on that particular skill has improved. So that becomes so problematic. You're not getting anything out of the IEP if you don't follow up on those points and make sure you have an accurate baseline, an apples to apples comparison, and then what you want, given the opportunity, is a more aggressive goal than non-aggressive. In other words, the district will often, say, listen, he's at 40% now. We think 50% in a year is about right, but really 10%, that's all you're going to improve Johnny's skill in this area? I would say that's way too little of an expectation for Johnny in a year's time. You want to be as aggressive as possible. Now, the law does not mean or say that if you don't meet the goal, there's some violation, right? There's no violation if Johnny doesn't meet his goal, as long as he's making meaningful progress in accordance with his circumstances. That's the law. That's the legal language. And what is meaningful progress? Well, the meaningful progress, the court has determined, is significant progress. It's progress that one is meaningful, but it is more than de minimis. That used to be the standard. And we have to get beyond that. And the way we get beyond that sometimes is by trying different things. So if Johnny's not making very much progress in a classroom of 25, but he goes one-on-one with a tutor and he makes great progress, now we're starting to see that much smaller class sizes or even one-on-one are what's going to allow Johnny to make meaningful progress, because we've established that meaningful progress for Johnny could be significant if he's in the right environment with the right supports, right? And so that's why these goals are important. It's why a goal in every deficit area is important, because it allows us to track progress over time. And if progress over time is de minimis, or even we see regression, that's the violation in the law that we take advantage of to make sure that district goes above and beyond to drive Johnny's progress so that it is meaningful for him. All right. Now, those are somewhat vague concepts. We will, over the course of the future of this podcast, get into all of that. Right. You'll get much more detail. This is a basic sort of 1 through 10 rules to follow to improve your child's IEP. But the whole point of this podcast is really to access these various rules one by one over time using individuals in this industry, so that as you continue to listen to this podcast, you get more and more information and more detail about what's going to help you drive your child's progress in school. All right. So I'm hoping that all follows well enough that you can make hay with what you're listening to right now. That is indeed the point of all this. All right. So that's 1 through 7. You've got, we only have a few left now. Number 8. Here is just one of the general rules that apply. And that is that your mom and dad, and I happen to believe my parents of my clients are the most knowledgeable about what the student needs to be successful in school. Nobody knows their children better than their parents. And very often it's the mom of the two that knows their child better than anybody else on the planet. Unfortunately, however, the law does not see you as an expert in your kid. Your mom You're emotion driven in many respects because it's your child, obviously. And even if you're the smartest one in the room, and very often my parents are, nevertheless, your input is not, unless you're a teacher, is not education driven, right? And the law sees education as unique and doesn't expect parents to have expertise there. And so they don't look to parents, despite their knowledge of the student, as experts. So sometimes, particularly when you're looking for a big ticket item, right? An expensive one-to-one aid or a private school placement that fits your child far better than the public school's classroom that has been offered to you and your child for learning. Very often those classrooms don't work. Very often they don't even work for neurotypical kids. And for our kids, kids on IEPs with learning differences, they very seldom work or don't work as well as we would like them to, right? So we're looking sometimes for expensive supports, expensive placements and services, and districts are always or almost always pushing back hard, right? The more expensive a service, the less they want to give it to you. So very often, your parent's opinion is not going to help us get what we want. So we want to think about bringing in experts. And for some of you, your experts are already there, right? If your child has autism, for example, or has been diagnosed with autism, you may very well have insurance-funded ABA speech and OT, right? Already not school-related, maybe home-based, maybe center-based somewhere, maybe school-based, but that's a little more unusual. The point is, you've got these people that are working with your child who's over time and getting to know them, who you can bring to any IEP meeting, right? You have the opportunity to bring anybody you want. You can bring a friend, right? Just for moral support. You can bring a friend who's been around your child so much that they can actually give information about how your child plays with their child, right? Or how your child acts or interacts with neurotypical or otherwise peers, right? If that's an issue in your child's case. So you can bring anybody you want. And if you're going after something that is significant, and by that, when it comes to school districts, often means expensive, then you want to bring somebody who has letters after their name, right, that apply to that area that you're looking at, right? For example, if things aren't going well behaviorally at school, you have an ABA therapist, a BCBA that is insurance funded that comes to your home and that is overseeing an RBT or a one-on-one aid, we'll call it, but in your home program. And that's going great because they're structured and they're consistent and everything works. And that's not what's going on in school. So bring your BCBA to an IEP, see if they will come and give input to the IEP team, right? And maybe if there's no one-to-one aid, bring the BCBA to lay the groundwork for contending that a one-to-one aid is what is required for your child to make meaningful progress. So some of you have some of these experts already in play in your child's life. Use them to better your IEP, bring them if they will come, pay them if you need to. Hopefully they won't require much. Very often they'll do it for free. But if somebody who is already in your child's sphere of influence educationally or behaviorally, or around communication, a speech therapist, etc., and they will come to an IEP and put things on the record using the letters behind their name, that could be far more powerful than you showing up and saying, well, this is what my home-based SLP says. If that's your plan, it's not very effective. And by that, I mean sort of summarizing somebody else's opinion about what should happen. The person needs to be there. They need to be able to answer questions. They need to have the expertise required of somebody in their position, right? So that when they speak, everybody listens because that's who they are, right? That's their profession. That's what they do. And the more, and even a letter doesn't take the place of a face-to-face meeting at an IEP meeting with your expert. So doctor's letters, we use them to get out of things, and they're very effective there, but they're relatively ineffective when a doctor recommends that the school add this service, because doctors are not seen as educational experts. But those people like a BCBA who's working with your child, or a speech therapist who's privately working with your child, those are seen as experts. And so the more you can bring them to an IEP, the better. And that includes IEE assessors. So what is an IEE? It's something we use an awful lot. It stands for Independent Educational Evaluation. So as you all know, if you have a child on an IEP, the whole process starts, and we've talked about this earlier, so go back and listen if you don't remember. But the whole process starts with an assessment of your child, an evaluation to determine if your child is eligible for an IEP. If you don't think they captured your child, or that what they did was appropriate, so that the report that you read about your child, you're going, well, that's, don't even ask me about Johnny. I mean, how do you put a report about what is happening with Johnny educationally or socially or behaviorally and not ask his parents? And you'd be surprised how often parents aren't interviewed. And you wouldn't be surprised, or you shouldn't be surprised to know it's a requirement that they do, but still they don't. They often do, but sometimes they do not. And it's a violation, right? So you get this report and you recognize that this is off. So you have the right at that moment to ask for an independent educational evaluation. Then you go outside, and if they say yes, and very often the districts do, you go find your own evaluator. And then they test your son or your daughter. They then come into an IEP and they sell their report and your recommendations. And you have 2 years after a district does an assessment to request an IEE. So it can be a very useful tool, because if they say yes to your request, they are now paying for your expert to come in, which is a wonderful thing that doesn't exist in the law anywhere else. It can be very helpful for parents that don't have the money to go get their own assessments, and because the district did not do a good job on their last one, the district is then required to pay for you to get your own expert. That can be very, very helpful, as can be therapists. So if you have a child therapist, right, because your child has emotional disorders or disabilities, high anxiety, depression, therapists are wonderful tools for us to bring into IEPs and talk about what that child needs, because a private therapist has, from an emotional standpoint, more information than anybody else, right? Even the parents will struggle to give opinions around how to improve your child's emotional health in a school-based setting, whereas the one-on-one therapist that's been talking to your child for a long time will have an awful lot of insight that you can use. All right? Overall message: bring in experts whenever you have the opportunity. Anything that's private, go find them if you need them for high-ticket items. Use the ones you already have. Go get an IEE assessor. All of those things are available to you, and you should use them whenever you can. All right, we're almost done. Give yourself time to review the IEP. Now, that is far more common now since COVID. I don't know what state you're in when you're listening to this, but in California, nearly the entire industry has gone virtual, right? I used to have to drive sometimes 3 hours to get to an IEP. I haven't had to do that in 4 years. Every single IEP I've attended since COVID has been virtual, right? So that makes it easy, right? It makes it easy for teachers to access, makes it easy for attorneys to access, parents to access, all and everything in between. It also makes it very difficult for for districts to hand you an IEP to sign at the end of the IEP. We don't see that anymore. We used to see that every single time. Now they generally take days to get you that IEP. And when you get it, whenever you get it, take your time with it. There is no rush. No matter what somebody in that district tells you they need it back for, they don't. Not as much as you need to read it and understand it and make sure it's accurate. Okay? Take your time with the IEP unless you're in a rush to get something started right away. Take your time with the IEP before you consent, and then only consent to the things you think are appropriate for your child. Which brings us to number 10, which is a tool that we use that is very effective. And it's called a Parent Addendum. And you rarely see them outside. You rarely see them if the parent isn't accompanied by an advocate or an attorney, because we use them often. We don't see anybody use them outside of really the legal field, right, or the advocate field. They're the ones, at least in California, that I've seen will use parent addendums effectively, but no one else. And it's a very effective tool. It is a letter, in essence, written by you after an IEP that lays out what you want out of that IEP that was offered and what you don't want, so that the district can start as soon as you consent. So that, right, and hand in your parent addendum. We'll talk about what's in a parent addendum in 2 seconds. But the district, once they get that, has to start on the stuff you consented to immediately, right? Or within a reasonable time, which is very quick. I mean, if they had to bring in somebody from the outside, they may argue, listen, it took us a month to find a nurse. And a judge is very likely going to say, okay, under the circumstances, there's a shortage of nurses. That's acceptable. But in essence, they have to really push to get a service in play once you've signed consent. So if there's something is critical in your mind that your child needs, then you want to sign with consent. But you don't want to sign consent in a blanket way. You want to, because there may be things in that IEP you don't want, or there may be things in that IEP you want, but that he didn't give you, right? That aren't in the IEP, services or certain goals. So the parent addendum allows you to do a number of things. It allows you to consent with exception, and all of the IEPs give you that option, right? Instead of consenting with a blanket check, right? I consent to this IEP, you go underneath that, and there's typically a box for I consent with exception. And then you write just with pen into that little line after consent with exception, see parent addendum attached. And then you attach a document that lays out what you consent to and what you don't consent to, and what you think they should have offered that they did not, that you laid out in an IEP that they ignored. Okay? Very effective tool. And then you ask them to attach that to the IEP, right? So that's one very good way of consenting by letting your objections be known. And the reader of the IEP not only understands what they're giving you, the reader of the IEP understands what you wanted but did not get. Okay? But here's another way to use the parent addendum, or in addition to that, actually, we do both. And that is, the IEP notes are drafted in every case, I think. I mean, I've never drafted one, so I know I don't do them, and I know my parents don't do them, but somebody at the district is. And sometimes you can have a 3-hour IEP meeting and a 2-paragraph summary of that meeting in the IEP notes. And very often, if that's the case, or even if there's a 3-page summary of the IEP notes, the key things, the things that really mattered to you, the things that supported, the evidence that supported what you wanted for your child that they neglected or refused, didn't make it into the notes. And if you didn't record and they didn't make it into the notes, it didn't happen. Pure and simple. You'd go back and, try and tell a judge, or, hey, they said this, and they look at the notes, it's not in there, and you didn't record. Trust me, didn't happen. But you recorded now, right? So now you can go back to the recording. You can actually reference the recording in the parent addendum that I just listened to it. And then you're going to make sure in that parent addendum that the key statements that supported the thing that you wanted, the service or or placement that you wanted for your child, you want to make sure you put it in the parent addendum because it wasn't in the notes. Now it's captured forever as part of the IEP. And the other thing you want to do with the notes in that regard is you're looking for things that are inaccurate. Very often you'll see things in notes. Nobody said that. Or somebody made a statement, but their inference was nothing of the inference that was taken in the notes, right? They really went beyond what was intended to create this scenario in writing that was not going to serve your child, right? Somebody said something about things going well and nothing to do with your child, but that's the way it came out in the notes. So you have to fix everything that's inaccurate. Doesn't happen that often where something clearly is inaccurate, but you have to look for them and fix them. But so those are the two things, right? On with the notes, you fix inaccurate things and you summarize and or quote the things that aren't in the notes that are important, that support what you want for your child that was otherwise rejected. Okay, those two things plus the consent with exception and then your exceptions are very important to put in writing, and then you ask for them to be attached to the IEP, and away you go. Right? So now you've recorded everything, so everything is captured, which makes drafting a parent addendum possible, right? And even, right, nobody goes back at a school district that I've ever known and actually listens to the record. So you can really set the record in writing very, very well because you've listened to the recording and you're quoting somebody, and that it can be very effective depending on the quote and its value as evidence for what you need. All right, that 1 through 10, all of those are how to create a more effective IEP for your child. Right? It's all about driving progress as quickly and as far as we can. It's making sure our child is heading in the right direction in all areas, right? School is not about academics only. Social, emotional health, right? Those are all what school is about. And all of them need to be supported in whatever program the district is offering for your child, right? You can't, to be able to trust the districts, and many you can. And if you're listening to this, I hope you can trust I hope you've developed a relationship with the school personnel that really makes you feel like, they're treating Johnny almost as if he's theirs, right? They're going to take control and really drive progress. And they've made it clear to you that's what they're going to do. If that's what's happening, you're probably not listening to this because you're doing very, very well with the program you're in. Unfortunately, we have 6 attorneys and we're statewide. We cover all 4 corners of California, and we're very, very busy because that just unfortunately is not typical. More likely districts are guarding the gates, right, of their finances, and they're very good at it. They get extremely good at it, and very often they can do it with a very big smile. And you have to just be wary of that, be knowledgeable, be prepared, put everything in writing, record everything you're entitled to record, which is every IEP meeting, bring in experts when you can, and ask 1,000 questions, and then put it all together in a parent addendum at the end. And you're going to find that the district is going to recognize you're a battler, right? That you're taking this seriously. You're not just coming in to listen to them tell you what your child needs. You're prepared to tell them what your child needs, and you have the evidence to back it up. And that alone will allow you to get better supports and services that will drive your child's progress over time. All right, I hope that's helpful. What we're going to do moving forward in the next podcast is we're going to have interviews with people in this industry, IEE assessors. I'll probably have 2 or 3 over the next year. Private schools where we place our kids. We place a lot of kids in this firm at schools that are designed for them, right? Nothing changes a kid's life and their family's life, really up and down, siblings and parents alike. When you have a miserable child in school who's not making any progress, hates it, hates to go every single day, and you find a school that works and they love to go every day. That change is so dramatic. It's quite impressive. So if your child hates school, consider reaching out to an attorney in your area and really figuring out if there isn't an avenue to get your child in a school that they will love. Right. So we're going to talk about all those things. We're going to bring in speech therapists, BCBAs. We're going to bring in as many people as we can that are touching this industry, and the industry being special education. Right. There's a whole bunch of people that deal with special education, therapists and counselors and school psychologists we'll bring in. We have access to all of them. Right. We've been doing this quite some time. So I don't know how all of this will play in your individual states. The law that is the underpinning of all of this is a federal law, so all of these things should apply. There's certainly true in California. It's a blue liberal state, so it tends to be a little easier at times to get things done, I think, than in states that are more conservative. I don't know that to be true. I just read the case results out of the circuits that are not the Ninth Circuit, and sometimes I wonder what it would be like to have a special needs kid in those states. But in California and everything I'm telling you, nationally, everything I'm telling you should work. Right? It might be a little more difficult to get districts to lay out funds for specialty schools that work in some states, but if you follow what I'm talking about, your chances of that are going to be far greater, most likely, than what you're doing now. All right. So that's what's coming in this podcast over time. If you're seeing this for the first time and you missed the first two, I suggest you go back and watch them. I'm going to be referring to these first three episodes a lot over the course of the next year because so much of what we're going to be talking about is the detail in one or more of these areas as we move forward. All right. I hope that was informative and helpful, and I hope to see you at our next podcast. All right. Thank you very much for joining.
You've been tuning in to the Special Education Essentials for Parents and Families podcast with your host, David Tollner. This podcast is not intended as legal advice and does not create an attorney-client relationship. Please talk to your legal counsel about your own situation. You can find this show on all the major platforms, including YouTube, LinkedIn, Facebook, Apple Podcast, Spotify, and on our website, TollnerLawOffices.com. Thank you for your positive reviews, comments, questions, and for sharing this show with others.